Call this meeting of the Tourist Rooming House Committee to order. Can I get a roll call, please?
Jenny Chadwick.
Present.
Phil Neese.
Here.
Tweed Schuman.
Here.
Stacy Hessel. Chris Rusk.
Here.
Gary Nathan. Matt Dale. Cheryl Treeland. Chris Vicelli. Martin Hanson.
Here by Zoom.
Ryan Carey. Laura Rusk. Okay, let's take these off. You have 1, 2, 3, 4, 5, 6, 7 of your team here. You have a quorum.
Thank you. Okay, let's rise for the pledge. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, do we have certification of public meeting law compliance?
This meeting has been noticed to the public and news media as required by section 19.84 of the Wisconsin statutes.
Thank you. And we have a couple here for public comment. First one is someone just wanted to have it read into record.
Whoops, that's Linda. You know what? She wants to speak.
Okay.
I know that's later. But anyway, Terry Hogan, Hogan. Okay. He does wish to speak, and he does not wish to speak, but he did have comments. And is how can a commercial business house that was purchased for rental only be conducted in a residential neighborhood? Can you start a resort in a residential neighborhood? I have had up to 11 cars and 3 boats parked in the driveway at one time.
And then we have Linda Zilmer.
Linda Zilmer, resident of the village of Birchwood, property owner at Edgewater, and my family goes back 4 generations in resorts and tourism. I really appreciate all the work that staff has done to bring forward to this committee and the public some really good presentations to help us all understand how their jobs work and what they do and what an applicant can expect. That's very helpful. I think there's a lot more work to be done. I sent an email out late last night with a lot of typos. It's a long day, but I think that all aspects of tourist rooming houses need to be covered while all the stakeholders are here at the same table, whether it's the zoning aspect or the licensing aspect. And the devil's going to be in the details. I think the Marquette example is good. I think the Barron County example is good, but I think it's premature to come forward with a recommendation without seeing more work. And also maybe give it a test drive as a tabletop exercise. What if scenarios once you have something drafted that addresses both the zoning authority and the licensing authority? And part of that is a follow-up to the previous comment is that there needs to be a differentiation between a residential use and a lodging use, which is more business or commercial and for profit. And I think zoning addresses that through conditional use permit process. Thank you. Oh, the other thing is maybe when attorneys speak, could there be some clarification whether the zoning ordinance and or the licensing ordinances apply to LCO properties or within the LCO boundaries?
Yep. Who's this? Yes, good question. I would recommend that whatever action the county takes, they take it countywide. So it would be by default applicable to LCO property. And then if there are certain individuals, property owners there who feel that they are not subject to that county ordinance, they can raise that question. But I would definitely recommend that any action you take be applicable countywide.
Thank you.
Thank you. Is there anyone online that would like to speak during public comment? No. Okay.
if everyone has reviewed the meeting minutes from the previous meeting, is there anyone that would like to make a motion regarding approval of the minutes?
So move.
Second.
We have a motion and a second. All in favor? Aye. Opposed?
Aye.
Okay. Motion carries. Okay, getting into the more important parts of the meeting, from my perspective, we had distributed for review to all of the committee members a copy of the Marquette County. It's a zoning ordinance, and it seems to be very much in line with a lot of the things that we have discussed as a committee. Most importantly, the septic system being, the septic capacity being used to regulate occupancy. So it was a very good example from my perspective. We wanted everyone to take a look at, and hopefully you've had a chance to do that, and we could open up the floor to comments on good, bad, whatever you think about that ordinance. Yeah, go ahead.
Is this ordinance something that the Wisconsin Counties Association is following suit or has a tension with?
Consider that. No, it's not being used as their sample or their model, but it's one of a lot of the components in the Marquette County ordinance are components that are being considered as that model. Do you want me to give a brief update on that right away? Okay.
Sure.
We're still essentially status quo because there are, as I mentioned last month, there's so many different issues that are bubbling up that it is making it very difficult to package it in a model ordinance. So we don't have anything yet. And I'm not sure I don't want to give a time frame. I don't want to speculate. But I'm very confident when we're gathered next month, we won't have one. So.
There's a lot of detail in this ordinance regarding the licensing process. It still deals mostly with zoning. And we'll talk about that in a minute too, because I know that had been a recommendation that we try to avoid. However, the components within that ordinance seem to fit very well within the discussion that we've been having. That's why we wanted to, pass that around and make sure everybody had a chance to take a look and get your thoughts.
Yeah, I'd like to hear what Eric and Matt and Jay think of this. Or we can start with these guys, I guess.
When I reviewed it, there was a number of items in it that I certainly think we can incorporate into whatever our recommendations are going to be, but it was far more in scope and a little different circumstance, but there was stuff in it that gave some ideas that went into the resolution that's going to come up before long. So.
So I've had a chance to review that. A lot of what is in here that refers to what we can enforce, we already are doing. The question is that, this came from a zoning department. So there's the question, I guess the questions I have are, if this is more of a health and human services and an agent program, going forward, if we were to implement something, can we enforce some of the stuff that is proposed in here that falls more on the zoning side of things? Like, I can only enforce certain codes. Zoning can only enforce certain codes. I can't enforce their codes. They can't enforce our codes. So that's where we got to just, regardless where this falls and what lab, if there's anything that comes of it, just how are some of these things dealt with, I guess.
Eric, did you want to?
Sure. I guess in my aspect of this, I didn't know what route we were going to take, whether it was zoning, ordinance, or HHS, like Matt was saying. But with my job in the septic system, it does give guidance for occupancy related to septic system. I don't know how many they have in that county, but to offer metering for 600 structures seems like a nightmare, and the math didn't add up to me. I don't see that we need to be that complicated, but if it is in code to allow metering, I guess we'd have to. So again, I don't think it clarifies whether or not you can do the commercial sizing in that county. It does?
No, it doesn't.
Oh, I thought you said, okay, yeah. So, 2 persons per bedroom must be septic system sizing. Metering, I just don't see it working out. I hope that clarifies that. I don't know who would be micromanaging water meters for use in 600 structures throughout the county. And if you're doing 150% of peak flow, I don't see how that would be an advantage to any structure. So.
Right. And then I did reach out to Marquette County specifically. I think it was Jean. If I forget her name, let me actually look here. It'd be the one that was referenced as part of their zoning department for their website.
Dean Potter?
Yeah, Jean Potter. So I did reach out to her. They have 78 licensed short-term rentals in Marquette County. And then I specifically asked about the water metering. They don't follow 383 for their water metering. They're taking a monthly average, and they do have quite a few that are going the monthly average route to exceed their 2 people per bedroom. So again, we're seeing a lot of different TRH ordinances out there that are kind of making their own little rules through the section of code. And again, they take monthly averages and they email photos to Jean. The tourist rooming house owners email their photos to Jean on a monthly basis. For 78 individuals and not 563.
Okay, anything else on this topic? Anybody on the Zoom?
Yes, Madam Chair, this is Martin Hanson. I am a little unclear on how specific you'd like comments on this item. And secondarily, I did prepare like 6 specific, fairly detailed comments that I could go through now, but I don't know how deep you want to delve into specific provisions.
Can you give us a summary?
Okay, I'll go quickly by section. Section number 1, it implies some input or authority from the town. It's unclear to me whether the town has any approval or denial authority, or what kind of recommendations and what weight they would have. Section 1A talks about a 1-year license period. After reviewing some of these ordinances, it seems like a 2-year period would be more efficient in terms of administering the number of licenses we'd have. My recommendation would be the initial license would be for 1 year, and then subsequent renewals would be for 2 years, just to cut down on the administrative paperwork. Item 1B, I'd suggest that inspections should be annual.
Hey, Martin.
Yes.
We're trying to follow what you're looking at. We are talking about the Chapter 35 Marquette County document.
Yeah, I'm talking about the
previously adopted Sawyer County tourist rooming house ordinance. Yeah.
Oh, 611.
That's the prior.
Yeah, that's the one from 2017.
Oh, I apologize. I'll withdraw then.
Okay, thank you. All right, well, that's all the comments we have on Marquette County.
So, Madam Chairman, how do we look to use this then? Is Rebecca and Jay and some other people going to sit down and take parts out of this and put it in ours, or are we just using this for information only?
Well, we wanted to show it to everyone for information only to start with. However, when we get to the resolution, that plays into that resolution.
There are, since there's parts that fall in line with what this committee has already agreed to, that was pulled out of there as part of the resolution. Okay. So the next item on our agenda is legal counsel update. And this is about that 2017 version that was adopted and then rescinded. And then anything else that you have regarding the state, the Counties Association, which I think you kind of already spoke to. So go ahead, Rebecca.
Thank you very much. All right, so I had a chance to look at the 2017 ordinance, and then in conjunction with that, I also reviewed the correspondence that it's my understanding was sent from an attorney to the county in 2017, and was not a legal opinion from your corporation counsel or outside counsel at that point in time, but that legal opinion was relied upon by the board in making its decisions to rescind your 2017 ordinance. So I also, again, I looked at that too, in case there were questions, and then also because that, you know, it is of assistance for me to look at how other counsel is looking at this from a legal perspective. So in the 2017 ordinance, I'll just put it this way. If this had come to me in 2017 and said, can we do this? I would have said, yes, but there are things, I know that's a great lawyer answer, isn't it? There are things in the 2017 ordinance that are concerning to me. I think that, and I'll go through those. But just to kind of give you a very high level summary. So I think there's some things you can do, but there's some things you can't do. I would not recommend that you, kind of pick this up, dust it off, and then move forward, not only because of some of the questionable items in it, but because state law has changed since 2017 as well. So we have to take that into consideration. So in the 2017 ordinance, kind of the reoccurring theme is it a zoning ordinance versus is it just a general licensing ordinance? Now, I wasn't here in 2017, but based on the information that I reviewed, it started out as a zoning ordinance, and then it kind of evolved into a licensing ordinance. And so right there, this has elements of both, which we've talked about in great detail, that you most likely want elements of both. So whatever action the county would take in adopting or in drafting and then potentially adopting a new ordinance, you want to make very careful. You want to be very careful in how you definitively define what elements are zoning and what elements are not, and how that's fused together. So again, it's careful drafting, as Linda said, the devil's in the details, and that's accurate. Not only primarily so it could withstand court scrutiny, because there are different levels of deference that a court is going to give in looking at a zoning ordinance versus just a licensing ordinance. And there's many, many layers to that legal conclusion. But again, for purposes of our discussion, it's something that's important to keep in mind. So, as I mentioned, there have been statutory changes since this ordinance was adopted, primarily to 661014, which I think some people refer to as the right to rent laws. We've talked about that before. There's certain elements that would need to be tweaked in this document in order to accommodate for 661014, which obviously, in going through the process of review this go round, we would do that. I had some concerns about from a general standpoint, and equal protection. The other legal counsel had raised a question about applicability to only single family homes, and I think it was 2-family dwellings, versus applying it to condominiums or resorts. That doesn't bother me as much as if you have a conditional use permit, then you don't need a license. That is that's a much more complex question of equal protection, because people who go through the conditional use process are obviously going through a different legal process and a different approval process with different, at basic level, different fees, but different standards, different terms, etc. So that was a question that was very concerning to me. In terms of the equal protection argument as it applies to condominiums, resorts versus single family, two families, that is an interesting issue, because when a court would look at this, they would look at it from, obviously from a general constitutional standpoint and equal protection analysis. However, this county has particular ordinances that relate to resorts, and they are regulated in a different way. So how those ordinances come into play when looking at an equal protection argument. So, and not to sound like a broken record, but those definitions of of resort in the ordinances do come into play here if we're talking about having certain applicability only to single family residences or multifamily residents, and not applying this to a resort. So, and obviously we can look at that in more detail as time goes on, but I wanted to mention that. Let's see. The rent issue of the $1,000 threshold. This is another good example where I think there was a good intent and a purpose behind that threshold. So is it within the scope of the county's police power? I would say yes, but it would need to be crafted differently. We just want to make sure that it is, that perhaps we could capture the intent in such a way that it would pass scrutiny, not only under, again, an equal protection standpoint, but there are restrictions on what the county can do in terms of regulation of rental amounts. The other legal counsel had talked about that in great detail in the 2017 correspondence. And a lot of that analysis I question, particularly because a lot of the sections that were referred to, you have to look at a statutory section in totality. You can't hone in and pick and choose. That's a rule of construction that a court will always look at, and that's what we as lawyers have to do. And the section that was being referred to, for lack of a better term, is a slum landlord section. That's the intent of that statute. Yeah. And so it's very difficult to pick and choose what elements to apply from that statute. And then also because now we have 66-1014, which is the right to rent law. So you have to look at all of that in totality. So there was a lot in that letter in terms of what the county can and can't do that I would question. On that point, I also want to with respect to that council's letter, another significant disagreement that I have with that was that grandfathering argument, that if the county were to, let's say that you decided to start regulating via zoning and require a conditional use permit, that anybody who was operating is now grandfathered in and wouldn't need that conditional use permit. That is not what the HEF case says. So that was very much a distortion of the applicability of that rule. And certainly when issues of grandfathering come into our discussions, we can talk about those. But that was a big point of disagreement that I had with that legal analysis. So I wanted just to point that out. And of course, it's a lawyer's job to make creative arguments at times, but from my perspective, that was a misapplication of the HEF case. All right. Let's see.
Are you through scolding me now for 2017 deal? I think you were.
No, I think, and as I mentioned before, I think that what you were intending to do would certainly fall within the scope of your police power, i.e. you have constitutional authority to regulate those things. It was just how they were put together and how they were memorialized that's a challenge. And frankly, that's not always your job, Phil. That's
Well,
for other professionals to do for you.
Kind of brings us around to where we're at here today on one level. I view what this committee is doing as a framework. And what we did in 2017 was try to write an ordinance. And that was a mistake because writing an ordinance by committee is not the way to do it. And because there's a lot of things that have to go into it, how the departments fit together, what we're going to use. And I view what we're going to do here today or going forward or whatever is a framework that we're not going to go into 15 different details on. Matt's going to have to call Jay on once a month or whatever. I think that's a whole nother world. I having played an attorney in zoning for close to 25 years on Fridays. This was a piece of crap. It was typical, throw as much at the wall as you can and hope some of it sticks. So that's what that was. And the county board, there was threats of lawsuits. And at the time they just decided to put their hands up, let it go. So anyway,
yeah,
moving on.
And in that situation, it worked.
Yeah, it worked. Sure.
You know, the nasty Graham can sometimes impact a legislative decision. Yeah. And when I say that, you know, in terms of the drafting process, I do think it is appropriate for this ad hoc committee to put together even a skeletal ordinance. And so I don't think that what you were doing in 2017 is inappropriate. What I'm saying, essentially, without critiquing, is you now have Jay at the table, you've got Eric, you've got Matt, you've got a really good group of professionals who can put this together for you. It
was actually Laura's fault. She was vice chair at the time.
No, nobody's fault. And again, the law has changed, so we're in a different landscape.
Yes,
and you know, now when this committee puts those ideas together, you're going to have a really good group of staff to be able to memorialize that for you. But I don't think it's out of the question that this committee can.
I think the idea
framework and ordinance
reviewing 217 was what within that, if we wanted to cherry pick it for a framework, is what could we get out of that? What could we cherry pick out of the Marquette or whatever counties we want to find that, you know, we don't have to totally reinvent a wheel. Mm-hmm. So anyway.
No, and I think that is always a good way to gather ideas. And that's exactly why it's great that this committee is looking at other ordinances, including your 2017 ordinance. Any questions?
I have a question, Madam Chair. So Rebecca, if you're gonna, like Mr. Neese mentioned, cherry pick out of all these drafts that you've seen already, when are we gonna see like a final draft so that we can move it forward to the, you know, we've been at this for months and I'm wondering, can we get to some point where we get something we can bring to the county board?
And that is our next topic. If we have any more questions for Rebecca, we should discuss those before we move on. But
by law, can you put a max number? Like right now we have 560. Could you say we are not authorizing any more than 600 in our county? You can't do that?
Okay. No, I would definitely not recommend that.
We're looking at an ordinance from a county that only has 78 when we have 550. It doesn't seem like it's comparable at all.
Yeah, and that is, you touched on, Supervisor Hessel, one of the, for me as a lawyer, fascinating components of working with Sawyer County, because there are so many unique elements here. You've got amazing natural resources, which people want to come and use, that then create amazingly challenging regulatory issues. And so even if WCA had a model ordinance, we would still be tweaking it for Sawyer County. And that's where, you know, obviously the value of WCA is to do that kind of groundwork and then make it particularized for each county. And so that's why I'm not too concerned that we don't have a WCA model ordinance for Sawyer, like with respect to my representation of Sawyer County, because ours would look different. Plus we do have the fundamentals that we can start working with, you know, for a Sawyer County draft. And then in terms of the cherry picking, that's exactly how we can do this, is, you know, pull the elements. If your directive is we like this, we like this, we like this, then, you know, we put it through the filter of legal and, you know, your other staff, and then we move forward.
In reference to, we don't answer back questions, but in reference, maybe she should clarify. The mistake, if there was a mistake made, was 20 years ago when we couldn't foresee what short-term rental was going to turn into. And if we were back in 2016 or 17, we might have could have done something different about regulating it so that we didn't end up with 560 or 600 or there's 800 or whatever. But then when the right to rent law went through, basically there was no way to, even if we had regulated it, it would have been gone. So anyway, is that correct?
That's correct.
Attorney?
Yes.
Okay.
Let me, I don't want to take up too much time here, but as long as I'm here. One of the other challenges, right to rent does pose regulatory challenges for municipalities, but the other challenge really lies in case law. We have case law that is very specific in terms of the extent to which a municipality can regulate a use that is residential, but done for commercial purposes. And that's really the peculiarity of short-term rentals and vacation rentals, essentially. Because when we're talking about residential rentals like we would usually think of, you have an apartment and you either have a lease or you're at will. That falls under a residential use. But so often, and I think we had a public comment that, you know, these are commercial uses, or certainly appear to be commercial uses, but more importantly, the effects are commercial impacts, traffic, noise, garbage, etc. Those are kind of the byproduct of a commercial use. We have case law that says, well, in some, there's one particular case that's a very specific example, but I think a court would also apply that you cannot prohibit residential or inhabiting use, even though you think it's commercial, in a residential area. So that is, from my perspective, that is the biggest legal challenge that this committee or any municipality faces. So yep, the statutes pose an issue, but we've got case law that's a challenge as well.
There's a question from Martin. You have a question for Rebecca?
Yes, thank you. You kind of answered it in your last statement there, but is there somewhere you can point to a quick study guide reference for the right to rent law, or just expand on what you went? I'm not familiar with the provisions and how that affects this committee. Thank you.
In terms of the statutory changes that were made, I know that WCA put out a memo to summarize what all of those statutory changes were. I can get my hands on that and send it to you, Jenny, if you want to circulate that. I know that there's other organizations out there that have also put out memos to summarize. DATCAP has summaries as well in terms of what those regulations are. To give a 10-second elevator speech on what it is, it limits what municipalities can do to rent or to regulate those short-term rentals. A lot of the, excuse me, on the face of it, it is directed at timing elements, but that's just on the face of it. You have to dig a little bit deeper in that statute in order to really analyze what municipalities can do.
Okay. Anything more for Rebecca?
I guess I have one other one. Do you have any kind of time frame on the WCA model ordinance at this point? Because Mr. Schuman had brought up, you know, if we are looking at potentially creating an ordinance and trying to cherry pick out of other ordinances that are out there, or our 2017 ordinance that was rescinded, would it also maybe be pertinent to potentially wait until there's a model WCA ordinance and then cherry pick on that as what we like and don't like, or what will work and not work for Sawyer County?
I'll be totally frank with you. I'm the one drafting the model ordinance for WCA. And so, well, Andy and I are drafting it. And
with Dan and the other folks at WCA and getting a lot of input from counties across the state. And so that work we're doing kind of in lockstep with this work. So you're, excuse me, the county is getting the benefit of that kind of the pre-draft, if you will, of WCA. And like I said, even if I had a model ordinance to hand out to you today, we would still have to Sawyer County it and make it, you know, applicable to all of the issues that you face. So I don't have a time frame. And again, because of all of these very unique issues that have bubbled to the surface, we're trying to figure out how exactly we want the model to work and to look like. So I don't have a time frame. However, because of mine and Andy's involvement in that process, I don't think you have to wait because we're already doing that work.
Yes, and I'd also like to just remind the committee that the county board, you know, tasked this committee with coming up with a recommendation, and that's what we're here to do. We've already been at it for several months. So I would like to see us keep moving forward as far as development of that one thing that we were given to do.
I totally agree.
Mm-hmm.
What I have found with model ordinances over the years is if where it's at right now will be a long time, and if you want to put the committee together next year, I think probably that's when the model ordinance might come out. So,
And Eric,
just a comment.
Yeah, no, and even like I said, if I had the model ordinance finalized sitting in front of me today, the discussion wouldn't be any different, because Andy and I are producing it for WCA. And I would still, right, and like I said, still Sawyer County it, like Sawyer County ties it. I think back to when we did the non-ferrous metallic mining ordinance that was 2018. That was one of the first model ordinances that I was involved in with, you know, on behalf of WCA. And Sawyer County, it was very similar. We did it in lockstep. So we developed that ordinance using the foundational work that we did for WCA as we were drafting that model ordinance. And then we Sawyer County'd it.
Okay, Eric?
Question for Rebecca. It's kind of a loaded question. Have you reached out to DATCAP or DSPS and have you heard any answers, recommendations, guidance regarding occupancy?
I'm chuckling because we have another county client who has had a very significant issue involving DSPS. And so I kind of know their phone numbers by heart by now. And the answer is no. I have not gotten an answer to that question. I have not reached out to DATCAP. And now that I think on it, I don't recall if I said I would, but I should, because I do still know some folks over at DATCAP. Yeah, it is incredibly frustrating. And I think the Marquette County example, and as Jay said, they're, you know, and kudos to Marquette County for fashioning it how they want to do it. Wait till somebody challenges it. That what you were told, Jay, from Marquette County is very surprising to me, very shocking.
Ms. Hassel.
So just thoughts. So when I signed up to be on the ad hoc, I thought we were going to listen to people's opinions. And then the people that are affected most by this are these three gentlemen in their offices. So would it be ethical for them to draft a ordinance of what they see fit presented to us based on all the opinions that we've had these last few months? Because no matter what we say outside of their offices, they're going to be affected by this. So is that something that we can do to have them draft their perfect ordinance on how it would best serve Sawyer County without taking away personal property rights, things like that, that we're all worried about? Can we task these three men with? At least we'd have something besides discussion.
I think
well, isn't legal going to work with these three anyway, drafting this?
Well, I think when we go through the resolution, it'll become apparent to what you're saying, that that's what's going to happen if the resolution passes. It's a framework for them, not to form an ordinance or a DACAP internally or whatever by the guys, but they're the experts and the ones that the minutia of this and how it can work between departments. So anyway, I would really think we should be for.
Okay, so we're going to move on to item 9, which is the recommendation document. Let me give you a little bit more background details on this particular document. Hopefully everyone has had a chance to review it. So where this came from, we'd made a motion early on from the committee that this committee's responsibility was to make a recommendation and not necessarily to write an ordinance. The committee approved following all the state statutes. That was another thing that was moved and approved. The Marquette ordinance does allow for the septic as a basis for occupancy. It also allows for the metering option, which was brought up as something that we should consider. The advice from legal was that we not do this entirely as a zoning thing with the CUP, the SP, and the grandfathering in particular being an issue. The document also has a public hearing process for revocation that does involve zoning, so that when something is determined to be beyond, acceptable by HHS, they can start a public hearing process that will allow for revocation of a license. The informational component is as per the webpage, and then that's why we distributed also the Marquette County webpage, which is excellent. They did a super nice job of putting all their information out there for the owners and for the neighbors. But also the lake associations have a piece in this, which we have some copies up here if anybody would like to look at the Tiger Cat Association booklet that is to be reviewed and put in every TRH on the Tiger Cat Association properties. Pretty much every lake association has one of these. And I think that the stipulation would be just to make sure that that gets shared. And then finally, we talked about contact information being important. And even the owners wanted to be able to have their contact information shared. At least that was mentioned in public comment. So based on that, this document is something, I pulled this together, but it's not my document. It's the committee's document based on all the things that we discussed as a way for us to come up with a resolution that could then be moved forward to committee to get into those details. Personally, I think it would be very difficult for this committee to get into those level of details just because it's a large committee. And once a month, this is going to take a very, very long time. So I would like to see us move this into the committees of jurisdiction with the guidance that this committee has presented. Comments, questions?
Why don't you go through the resolution?
Okay.
Point by point, and then we can stop if somebody has a question. What was put into the document?
Then, Madam Chair, I'd like to hear from legal. They reviewed it and your advice. Either whoever goes first.
Yep. Would you like to go first, Rebecca? Okay. Well, this is the one it's a page and a half. Okay.
Both sides.
Yeah, it's not super detailed. And that was really the point. It's resolution of a recommendation by Sawyer County Ad Hoc Committee on Tourist Rooming Houses. Whereas the Sawyer County Board of Supervisors has created the Ad Hoc Committee on Tourist Rooming Houses to deliver a set of recommendations for the regulation thereof. Whereas Sawyer County Health and Human Services is an agent of the state of Wisconsin for licensing TRHs. Whereas the state of Wisconsin allows for commercial TRHs to operate in residential zone districts. Whereas Sawyer County Environmental Services is obligated to follow ATCP 72 and DADCAP code requirements for POWTSs. Therefore, the Ad Hoc Committee on Rooming Houses recommends the following means of properly licensing TRHs.
I would have one comment there. You did say you wanted to kind of go through these. it would be my recommendation you would change that, whereas Sawyer County Environmental Health Services is obligated to follow ATCP 72 and DSPS code.
Got it. Thank you. Okay, licensing requirements. Number one, no person should operate or may operate a tourist rooming house without a license. Number two, a local contact person shall be identified as responsible for the property and have the current property owner's contact information. The local contact information will be provided by the property owners to the neighbors within 300 feet.
Madam Chair,
Yes.
under section 2 as read, I have a concern. Overall in this resolution, does this establish the boundary of how far it goes? In other words, as you say, local contact, and how do we determine how far away a local contact is, the travel time, availability, 24/7, response time? And then again, within 300 feet, is that the distance from structure to structure, from a property line? Or what about an extremely large parcel that is over 300 feet in every dimension? Then they don't have to notify anyone. So my overall question is in this resolution, are we setting constrictions that going forward, it can't be any more restrictive than what this resolution says?
No, I think the resolution is the guidelines in the framework, and then it's determined by the people that are involved, where's 300 feet, and normally it's 300 feet from the property line. So, but that is the kind of detail that needs to go into a final ordinance or what's going to be passed by county board, rather than us trying to dig into those details here. The point of that particular line is that the people that are adjacent to the property are being informed of who they can get a hold of. Now, how that can be done is the reason we've got all these smart guys here.
Yeah, and thanks for that clarification. But when we get so specific as 300 feet, my concern is that somebody's going to look at this ordinance and said that you didn't follow your own, or not the ordinance, the resolution. You didn't follow what you approved in the resolution because it is more restrictive than what the resolution says.
No, I don't think anything within this. This is just a recommendation. It's not. If for some reason they think it should be 1,000 feet, why that's for them to determine. But you need to have some kind of something for them to shoot at.
Okay.
And then I believe the zoning follows the same verbiage for sending out notifications for rezones.
Yes.
So that makes sense.
Yes, that's what it's patterned after. Okay, the next one is on contact information, which should be posted on the exterior wall near the main entrance of the residence, only when occupied by renters. The address of the property, the emergency contact information, local contact person's telephone number, the occupation, the maximum number of occupants, and their permit number. Number 4, each tourist rooming house shall comply with the following minimum requirements. So this is where we're getting into the stuff that Matt, he had said that his department already does. Basically, this is saying, as we said earlier, we're going to follow all state statutes. So the administrative code requirements for habitable rooms and occupancy. If occupancy calculated by space exceeds the design occupancy of the septic system serving the tourist rooming house, the applicant shall limit occupancy to that of the septic system design. So this is the change. It's important to note today they follow based on space. If the space is greater than the septic system design, it's going to default to the size of the septic system for regulating occupancy. If the applicant seeks to exceed the septic system design occupancy, a water meter shall be installed by the property owner on the water service entering the tourist rooming house. So this is the piece that we took from Marquette, and they obviously aren't following it, but the implementation of this would be left up to you folks and as it gets down to committee.
And Marquette did it an interesting way because they didn't reference the actual state code. They just said water metering, and then they ended up basically calculating their own design as a monthly average of wastewater flow, but that's not necessarily what 383 states.
So this statement is clear in that it says, if the water meter calculated daily flow exceeds the daily design flow of the septic system as defined by state code, the occupancy shall be reduced or the septic system shall be upgraded to meet the increased flow. Item number 8, contact numbers must. I'm sorry.
Under 4B, does the current license application have the specification for the septic system design for capacity? And if not, I think it should be. And I'm just wondering if this resolution ought to include that the septic system design capacity should be provided by a licensed septic system designer and part of the licensing application.
Yeah, this is Matt. No, currently the application does not require that information.
I would suggest we add that to the recommendation here.
Exact verbiage was that?
Yeah, what was that? Can you?
The septic system design occupancy should be provided by a licensed septic system designer and be part of the license, stated on the license.
Is that what we have in the Novus today, Eric? I mean, I've looked at the documentation for my property in Novus, and it is a document signed by a inspector.
So I reached out this winter to a counterpart in Minnesota, and they have what's called a compliance inspection form that could be a tool that's used for a green light for Matt to proceed with licensing if everything else is met. Some type of a compliance form from zoning requiring occupancy, code compliance, other things is a sanitary permit, a valid sanitary permit on record, setbacks, all those things, whether it's our office or whether it's a licensed plumber. I'm not sure how we want to direct that, but we can go into the details of that. And I guess one other thing regarding that section that we've talked about quite a bit, do we want to include commercial sizing in this section as an option for occupancy?
Okay, two things. First of all, I want to clarify what's in our database now. Isn't that considered a legal signed off on description? If I go into Novus and I pull up the zoning and pull up the SAN report, it's right there.
I'm not sure if the general public would be able to read and digest all of the information on a sanitary permit as to number of people based on septic info. You could have a 1,000-gallon 3-bedroom tank, but only a 2-bedroom drain field. Therefore, it defaults to a 2-bedroom. So unless you're a POUTS inspector, a plumber, I'm not sure who would be able to sign off on compliance of that system for occupancy.
That's precisely why I think it's important that we finally nail that down if we're going to judge occupancy based on septic system design. So that ought to be determined and be publicly available.
He's asking for all of this to be more specific.
Right, but I think it's very difficult at this point in the process for us to tell them how to do it. You know, we need to give them the direction, but not necessarily how it's going to get done.
Rebecca had something.
Yep. Go ahead, Rebecca.
Yeah, I think a requirement that an applicant for the license, I'll just call it the license that we're obviously talking about, have a separate inspection that is required by a master plumber or a certified POUTS inspector is a burden that I'd want this committee to think about. Number one, cost. Number two, time. Those folks they're really hard to find right now in this day and age. I mean, you guys can speak to that. From an administration standpoint, if now you have to check another, like, to make sure the master plumber was there before you issue the permit, I don't know. I just see a lot of concerns with that. But that being said, I get the question and the intent to make sure that these folks are complying. And so maybe there is a different way we can capture that concern without specifically stating what they have to do.
When I look at my old permit, when the septic system was put in, it showed how far it was from the house, how large the tank was, and how large the next thing, and it also showed the length of the and how big the field was. I don't know why if it's 50 feet long and it's $1,000, yeah, right, 1,000-gallon tank, that it can't be determined that this is, you don't need a master anything to.
Right. So you're the fortunate one that has a valid sanitary permit. I guarantee there are TRHs out there that do not have a valid sanitary permit. Where do we go from there?
Well, then they're going to have to get one, and they should have one. I mean, just because people didn't have one or don't have one doesn't mean we shouldn't require it. I don't have a driver's license, but you know.
So, okay, what if we were to change a proposal to add some verbiage? Maybe I should wait for Stacy to come back. Because I think she had some concerns with this too. So in 4BI, if the applicant seeks to exceed.
Yeah, can I make a comment?
Oh yeah, sure.
Okay, so I think that this, just more of a generalized comment. This is a really good place to start. So the committee can keep making forward progress. I think it would be more appropriate for the general terms to be talked about, which again, you've put on paper for us, but not specific wordsmithing at this point, because there's other sections that I would be wordsmithing to.
Okay.
That makes sense?
Yep.
And so, I would hate for the committee to take the time to go through like specific wordsmithing, and then what you get back looks very different because I agree. Doctored it. If you like the general scope, I think is good.
I agree, Madam Chair. I think we're just approving this resolution, giving marching orders to legal and our department to go forward with this and all the minimal requirements and concepts that this committee put together.
Yeah.
So there'll be fine tuning by legal and these three fine folks over there. They'll add a lot of this.
Okay. Very good. So moving on, number 5, sleeping rooms that meet the requirements set forth from ATCP 72.14. Any concerns about that, Matt? Is that what you're doing today?
Yes, correct.
Okay. All tourist rooming houses shall comply with all applicable Wisconsin administrative code chapters, including ATCP 2072 and SPS 362. Again, from the Marquette document. Number 7, no RVs, campers, tents, or other means of shelter that would exceed the maximum occupancy of the dwelling area are allowed. That was also in the 2017 document.
And I just want to kind of add a little clarification to that line. So anybody that would to advertise that, guests could pull up their camper to the house that they're renting and, create additional space, sleeping space. That is obviously not allowed, because then they're at that point advertising as a campground, which they are not licensed or permitted to do. So maybe it's not made perfectly clear, but it's noted that, owners, managers of tourist rooming houses are not allowed to have additional units, being campers, tents, that kind of stuff at their properties.
Thank you, Matt. Number 8, outdoor parking for overnight or day guests shall be limited to designated parking areas on the TRH property. In no event shall parking for TRH guests be in any public street right of way. Just stating that it's going to be on the property
Madam
somewhere.
Chair. Madam
Yes.
Chair. Yeah, I have a concern here that does parking include passenger cars, SUVs, trucks, trailers, ATV, UTVs, motorcycles, golf carts, and some of the other complaints that we've heard from the public about things other than just guest vehicle.
It encompasses it all.
Yeah, it's just parking in general.
Yeah, sorry. I guess if we are gonna put something in on paper, that would be, not only streets, highways, whatever, but also looking at language probably for easements and private driveways.
Yeah.
Okay. And then number 9, must pass a tourist rooming house health inspection by the Sawyer County Health and Human Services Department as agents of the state of Wisconsin. Added the next statement, which is Sawyer County Health and Human Services shall have authority to revoke or withhold renewal of a license if the requirements are not met. And that means the requirements of the previous section that we just went through. Next is the public hearing process. At the request of Sawyer County Health and Human Services, who will determine the criteria for requiring a public hearing, Sawyer County zoning will implement a public hearing process under section 35.14 to determine if a license should be revoked. A license may be subject to public hearing and revocation if it is determined to be out of compliance with the licensing, have an adverse environmental impact, have excessive noise complaints, have an excessive response required from law enforcement. Again, there's no specifics on this. It's a generalization. Go ahead.
So this wouldn't necessarily really need to be recreated because it already exists in our ordinances for agent of the state. And so we have criteria for denial, suspension, and revocation of a license. So much of that language is already
have it
developed.
That's fine. We don't need to take out of our record.
I mean, we can look at it, see if we need to tweak it.
Well,
but
you guys have to
yeah, exactly.
Good.
Okay.
And I think the reference to that section 35.14 was probably from the other counties.
Yes, it is.
Section.
Yeah, it is.
Okay.
Yeah.
So we probably want to have to change that
Take that
section number to something
That's
else.
their 35.14.
Right.
Gotcha. Rebecca?
Thanks. The public hearing process, keep in mind that that goes to the due process that is required for, any sort of penalty or regulation. So when this comes back, this one is going to look different. But again, this is fantastic because I see what the intent is. But as Matt indicated, we have to make sure that it jives with our other sections, jives with obviously state law, but then also that we are very careful in making sure that the opportunity for a public hearing is uniform. We don't want, so for example, if someone has excessive noise complaints, then our staff gets to decide who gets a public hearing. That wouldn't work. So it has to be a very uniform.
Based on criteria. Yep. And I
Yes,
think
we can have
that's
the criteria, but again, just a uniformity. That's going to be a key point.
okay. Yes. And the next statement sort of backs up. Sawyer County Health and Human Services will determine the criteria for fees, penalties, et cetera, to support the enhanced licensing process. Andy?
Probably the same question as Rebecca. I just wanted clarification under public hearing process, the first sentence. Is that saying that, well, it says down below that Human Services will determine the criteria. Is that upper section saying that Human Services will request that a public hearing be held? Like staff will do that?
We'll determine the criteria. So if it's 3 letters of objection, for example,
Okay.
or 3 calls to the
So they
sheriff's
determine the
office.
criteria though, but then do they have to request that zoning hold the public hearing? Is that what that?
Because the public hearing process falls under zoning.
Okay.
No?
No,
No?
not
Doesn't have to?
necessarily.
Good.
Nope. Mm-mm.
Jay, you can go back to your office.
No. Because I guess who's going to be sitting in that public hearing?
Because I mean, yeah, and I understand that this is setting a framework that we need to put the details to. But when I read through this was the most troublesome area to me. Because one, it's subjective, like what is excessive, but maybe Matt's saying he has some of that criteria. Like, is it the number of complaints or there's one really excessive noise weekend? You could look at that different ways, but then just who's the one that says we need to have a public hearing or we're going to put this unit up on the block to decide if they should keep a permit. I think it's troublesome to have just staff doing that. I don't know.
What if there's a specific requirement, it's nobody's personal decision at that point.
And I just think A, B, C, and D need to be definitive.
Right. And I think, like Andy says, this is where we got to be careful because, and I think I've explained it in other meetings, that, you know, we could have one neighbor that watches like a hawk their neighbor and they stepped 1 foot across the easement onto their property, or somebody backed into their driveway, and they're going to call on every single situation. And is that 3 strikes and you're out kind of thing? That's where we've talked about that ever since we've been an agent of the state. How do we regulate that, and how do we document those calls and those situations? That's where I'm asking for the help, because how do you I can't just make that sole decision. It's like, yeah, that sounds like 3 strikes. I'm going to just, no, I can't do that. So that's where we got to be careful in how we craft this. Yeah, exactly.
That's the reason we have you.
And that's also where staff discretion and enforcement discretion is going to come in, and that would be in a draft. I think it's also important too to keep in mind that a public hearing would be, or could be, I would recommend that it be triggered upon revocation. So again, if you meet certain criteria, let's just say the 3 strikes, whatever those strikes might look like, and then a process is followed similar to revocation of a sanitary permit or revocation of a zoning permit. Criteria established, and then once you get to the point of revocation, that's when the public hearing occurs. So again, uniformity, equal treatment, and then as Matt indicated, some very as specific as we can get to guide that discretion in the ordinances is the key, and then finding that healthy balance.
Okay. Does anything need to be clarified here at this point? Further clarified? Okay. Moving on. Last paragraph, Sawyer County Health and Human Services will implement an educational webpage for the purpose of improving the TRH experience for owners, renters, and neighbors. The webpage will include licensing resources, documentation, on how to get a license, program contacts, a brief explanation of the purpose and history of the process, and good neighbor guidelines, including contact information for lake associations and other entities that provide visitors guides to be displayed in TRHs based on the property location. So links to things like the Tiger Cat Association or the COLA resources that are being provided today. And that's our document.
Any other comments?
Any other comments?
Well,
okay, just I'm going to try to do a quick summary. So we've got our marching orders. So we talked about obviously the local permit requirement. Is this going to, do you want this to fall under zoning? You want this to fall? Okay. I just wanted to make absolutely clear.
Can we clarify permit or license? Because that's interchangeable, and I think there's a big difference.
Yeah.
I think there's a big difference too. And there is a big difference. And unfortunately for me, from a legal perspective, they're so often used, and I'm sure for you too, they're so often used interchangeably. But what term you use is the basis for which the grants or the rights that you are granting to that holder define. So I'm envisioning this as a permit with all of these components and we can talk about how that is going to start and that process. Notifications, obviously, the minimum requirements we talked about, the rules of use that you've included here and we've commented on, then the revocation provisions, and the educational website. So those are kind of the generalized categories.
Correct.
One other follow-up question I had with respect to the local contact being provided to owners within 300 feet. I'd like some direction from the committee on the timing of that notice. Is that an annual notice? Is that whenever the permit is issued and then renewed? For a couple of reasons. Oh, and who provides that notice? You know, I don't know what's in.
Well,
Jane, Matt, and your
we said the owner would provide it.
Okay.
Whoever the owner would provide it, and I would think when the permit is issued, or if it's already been issued when it's renewed, he would be required to, at that time, to inform those neighbors, and he wouldn't have to do it every time, because unless he sold it and it wasn't rental anymore, who cares? Right.
So then the permittee just has to provide proof of notification given to those. Okay, got it.
But I think it should be annually because the homeowner next door could change.
Mhm.
So I think it should be annual.
Along with the license renewal.
Yeah. Okay. I don't
Great.
Yeah, there's, excuse me. I guess I have some doubt about that because just of that and just the amount of time that would take to the number of letters that are going to be going out. We have 950, give or take, licenses for what we do as an agent of the state. And now I know we're talking just for Tourist Rooming Hub in Sawyer County. But to send out those letters on an annual basis
you're not doing it.
The owner needs to.
The owner needs to do it and verify to you that he's done it.
Right.
That's all. You're not sending them out.
And
The
then
only way you could verify it at that point would be through certification of mail.
or when they sign their application,
They could
they're
sign an
essentially
affidavit that
signing
they
as an
provided.
affidavit
Sure.
that you did this.
Yeah.
And if there's
If they
a
didn't,
question, if
then-
they
Be
did
one of their strikes.
Yeah.
one of their
Which is
strikes,
better.
right? And those are all questions of fact that in a particular situation,
Right.
in a revocation hearing, you'd have to sort through.
But I would like to see the owners take more responsibility instead of our agencies. And I think that that's what I'm asking for is they send that out annually. They do the work, they do the packets, the signs, not our agencies. So
Absolutely.
yeah, I think if they're going to make money and cut into our housing issue, then they need to do more of the work, not our agency.
Yes, agreed.
And you can also capture that in the permit application fee, which I, would encourage you to do. And then there's, if there's other mechanisms to offset costs, we can talk about those too as we put this together.
Okay. Any other comments?
I guess just going forward with any criteria for an ordinance is that I guess I ask on behalf of our department and probably zoning as well, is that whatever language goes in there, that it's reasonable, that it's doable, it's that something that we can actually do in the field, and that is
We're giving you the.
Well, Matt, you three are the ones that are gonna do it. You're doing the
You're gonna write
crossing the T's and dotting the
right.
I's,
But I
not
mean, what I'm saying is
back.
not get so specific that, okay, we're going to measure every room in the building for cubic footage, and
then you don't put it in there.
right. So, but I mean, as far as suggestions for us, that, we got to make sure it's reasonable and that it doesn't get so detailed that it overwhelms us as what we need to do in the field, because we just got to keep it realistic.
Well, part of the reason for returning it to you, so you know that it is, because we don't know what would overwhelm you. Okay. I know you have great capacity and you wouldn't mind being out at 2 o'clock in the morning, looking in windows, seeing how many people are sleeping or whatever.
Strike that on the record, please.
Anyway, I would at this point, or you got a question?
Yeah, question, comment. I don't know if this is picked up anywhere else in the permit or license process, but for number 2, where they have to send a letter to the property owners, I think they should also send a letter to the local municipality with that same information. That way, the municipality also can keep track of making sure they pay room tax. And if they get complaints, they know where to spend them back to. And I think it also ties into the parking, that section on overnight parking is on premise. You know, we can put that in there and verify that they have overnight parking, but we can't prevent people from parking in public right of ways unless the municipality is posted no parking signs.
I guarantee you, most of town roads are so small. If you got one car, you're out of luck. Parking, but
yeah, but that's a good point because that puts it back. I mean, the town has to have a parking ordinance,
which most towns do. Anyway,
I got one
good
clarification with Matt. Currently, Sawyer County acting as agent of the state from DATCAP. Are you permitting TRHs or licensing TRHs?
We license them.
And we would just make sure that our ordinance captures the right legal definition. So if people want to call it a permit, they want to call it a license, we know what it's going to be from a legal standpoint.
You suggested permit. Why over license?
Technically, and I'd have to, again, state calls it a license, but we can call it a license, but we have to look at what rights are actually granted in that. A license is an elevated property interest over a
fee.
permit. So when you think of your bundle of sticks that you get when you're you have a property interest, a license is a bigger stick. Again, from a purely legal standpoint. So we want to make sure that the county is not granting some sort of heightened property interest in the issuance of this thing. Because again, if then the county needs to take enforcement action or revocation action, the due process is increased. We do not want to get to a level where what we are granting could ever be construed at revocation would be construed as a taking. Do not want to get to that point.
So would it be ethical to call it a state license? So when you're referencing the state license, but the county would be referenced as a permit allowing the license.
Yeah, I look at this as how this is coming together. And again, fantastic discussion. So we're actually putting everything together as using your state process. And again, the extent, so workload is not expanded, and piggybacking off of that. So obviously they have to have the state approvals and then the county approval overlays with that and then supplements to the extent it can. So it would be a permit. I don't think that from a purely legal standpoint, what DATCAP is issuing meets the legal definition of a license. But again, those terms, I mean, when you look through the administrative code, you've got terms like certification, license, permit, approval. They're kind of, again, they're used interchangeably, but you have to look at what exactly the person can do and what rights they're granted with that thing, whether it be a permit or a license. I just like to call it a permit and not a license because I don't want there to be any indication that we are granting a greater interest than what is being intended.
Okay. Do you need a motion to approve this to move on? So
you're going to make a motion?
I would make a motion to approve the recommendation for our 3 gentlemen here to work with legal to get this going.
I'll second that.
Is that approving the resolution then?
Yes.
Okay.
Okay, we have a motion and a second. All approvals?
Aye.
Aye.
Opposed?
Yeah. Any opposed?
Nay.
Okay.
I think that was Martin. Martin, was that you?
That was correct.
Okay.
Can I?
Okay.
Now that you've approved it, can I question the approval? Is this the intent was just to give a outline to the staff? You're not referring this to the board for any adoption?
Okay. Staff.
Thank you.
Go forward. Yeah.
Correct. So now, as a committee, I think we also need to decide, is our work done?
Done.
Or are we going to try to stay involved in this process at any way at this point?
What would be our mission would be to approve what they give.
No.
That would be up to county board.
It would be up to county board.
But would it go to zoning to bring, because it has to go to a committee first before it would go to the county board. So what committee would it go to if it's not ours?
So as per the resolution you just approved, there's very limited zoning input besides a potential revocation of a permit through the Sawyer County zoning process. I don't necessarily think that the ad hoc committee work is done because I'd like to clean up the resolution that you approved. And then I would at least like you to take, one kick at whatever draft requirements that we come up with before moving it on to a level of jurisdiction. And also potentially the TRH committee give us the guidance as to what level of further jurisdiction we move this to.
So that's why I asked, because if they thought that we were done, and which I didn't think that we were done, because we have to see what you guys do. That's why I thought that they were kicking it to the zoning, and I don't approve that. So my thought is that I would like to make this done in December. So we're not going into the new year still in discussion. So if we can meet next month, still at ad hoc, approve, or else at least at December and approve so we can then be done.
Well, I don't know that. I don't know if they can come up with something that fast. Is it that hard? Is it that hard, man?
I'm gonna look at that, Rebecca.
Well, she'll work overtime.
Well,
She's
Andy
got a
too,
good
right?
fee.
Andy's got to be involved too.
Well, I think it's mostly going to be legal.
What'd you add? You got me?
Andy would be involved.
Mhm.
What? How long?
I guess I just have,
Well,
I don't know,
you
this is
think
just a
from
thought,
my
I guess.
committee?
but- I'm sorry.
Yeah.
Yes.
I'm confused where we are.
So that's, I guess, yeah, I mean, as we draft this, are we looking more leaning towards it being an agent or health and human services ordinance? Are we looking to write it more as a zoning? It sounds like it's more health and human services, which that's fine. But then I guess my questions are, if we're looking at septic systems and addressing occupancy based on the sizing, and again, going forward as we have already approved to do so, to look at commercial versus residential, can our department enforce some of those statutes and ordinances?
No, and I think I have a solution for that. We talk about the occupancy designed on the septic system. Now, if we are doing this as some type of permit, that we would actually have a physical permit, we could have a zoning sign-off portion to verify that it meets the sewer system sizing based upon occupancy. I don't think you need an actual, plumber to do that, or an actual, POUTS inspector, if there is a valid sanitary permit on file. If there's not a valid sanitary permit on file, that becomes an interesting situation where we may want to have language within those requirements, and that's where a licensed plumber needs to sign off on the design occupancy of that. Or we just say that they're not able to rent that as a short-term rental because they don't have a valid sanitary permit. That'd be an interesting legal question, because we do have some sewer systems predating zoning that don't have sanitary permits on file.
We just gave you permission to talk about it later.
Right.
Okay.
But again,
Madam Chair, I got a question. Andy, what would be the committee of jurisdiction then? Because then the county board would hear it after it comes from there.
My opinion right now is that, most of it's going to be human services through public health, but that zoning should also see it, because you're going to be, I want to say enforcing, but implementing statute, approving based on statutory guidelines or administrative code, whatever it is. Both. Okay.
I'd make a motion that
We're really not writing any new ordinances in zoning. It's just the way you apply existing code, correct?
I make a motion that the committee stand adjourned until it's called back into session by the chairman, that we have a document to review that has been being presented to us back from our recommendations. Yeah.
I'll second that.
All who approve, say aye. Aye.
Aye.
All opposed? Motion carries. Good job, guys. Thank you very much. We stand
At my age,
adjourned.
it better not be too long.